everyone. Welcome back to ARCS Chat. My name is Robin Bauer-Kilgo. I am the Association Manager for ARCS. A couple of quick tech tips. As we live stream this talk, there is a slight delay between the actual meeting and then as it beams out to YouTube. So just know that if you're chatting along in the comments, that there's a little bit of a delay. So just heads up on that. And a couple of quick programming notes when it comes to ARCS. You can now register for our virtual conference. It's happening in November. 2 weeks of programming. It's pretty much the biggest conference we've ever done with, my gosh, over 35 sessions, networking opportunities. If you're a member of ARCS, it only costs $100 for full access. So I really encourage you to go over and register for that conference. We're looking really forward to it. We also have an event on September 30th. It's called Ask the Art Lawyer. It's actually connected to the contract service agreement that you can now purchase on the website. The lawyer who actually helped to develop it is going to be available to answer questions on that service template. So if you're interested in RSVPing for that event, just go to our website, arcsinfo.org. So I'm going to go ahead and turn off my camera and hand this over to one of the hosts of ARCS Chat, John Robinette. Thanks, John.
Thank you, Robin. Welcome, everybody. This is exciting to be back. Very, very exciting because ARCS Chat is going to take on a new patina this year. And, to get things started, we have a wonderful panel of guests with us today. And first off, I want to introduce our regular co-host, Amanda Robinson.
Hey, John. It's Amanda here, coming to you from the Museum of Fine Arts in St. Petersburg, Florida.
Fantastic. And joining us is two new ARCS Chat panelists that will be with us for the rest of the season. I want to first introduce you to Meg Thomas. Meg, tell us where you're from and a little bit about yourself. What do you do?
Hi, everyone. Yeah, my name is Meg Thomas. I am from Wilmington, Delaware, and I am happy to somewhat announce that I will be taking up a position at the Delaware Art Museum later this month.
Fantastic.
So,
congratulations.
Thank you all.
And Kristen, join us. Tell us about yourself.
Hi, I'm Kristen Guinan-Wiley. I recently graduated from the George Washington University Museum Studies program, and I am soon to be starting contracting work with the National Museum of Natural History at the Smithsonian.
Fantastic. So Meg and Kristen are going to be sharing some of the hosting duties as we go along this season. And so they are fully integrated into the chat. So we want to welcome them. As always, of course, post your questions in the chat. So today our topic is restitution and repatriation. So of course, we've seen quite a lot of very public repatriation cases and restitution cases happen over the last year. And to find out more about that, we thought we would go to the expert from the Institute of Art Law. The Assistant Director, Alexander Herman, is with us here today. And Alex is the Institute of Art Law is from the United Kingdom, though Alex is based in Canada. He is the assistant director and oversees all of the academic content there. But for the purposes of our discussion today, he's also coming out with a book called Restitution: The Return of Cultural Artifacts. So this is going to be released later this fall. So Alex, welcome to the program today.
Thanks for having me.
Of course. So we want to basically, we'll start at the very beginning and define restitution for our audience here.
Yeah. So, restitution is an interesting term because you often hear it bandied about in the museum sector and the cultural sector at large. But the truth is, the way it's used, the way it's discussed in our sector, it doesn't have a consistent definition. It doesn't have a legal definition. There is something known as restitution in the legal world if you go to court. But I think what is usually being discussed in relation to museum objects and the return of museum objects to their countries of origin or communities of origin, it goes a little bit beyond the strict legal definition. So it's, in a way, it's a term of art that's used. I usually like to define it as the return of cultural objects as a way of doing justice for a past wrong or a continuing wrong that's been committed. So there's an element of injustice that has been committed maybe sometime in the historical past or the recent past. And we see restitution as a way of trying to make amends for what happened in the past through the return of the particular object.
Great. Okay. So we need to clarify one thing, and this is something that I get confused on all the time, is what's the difference between restitution and repatriation?
Yeah, so those are two terms that, again, sometimes they're used interchangeably. Certainly, if you read media reports, you hear about a repatriation to another country, you hear about a restitution, sometimes involving Nazi looted art going back from a museum to a family. Again, repatriation is a slightly different term. In the U.S. context, which is where most of your listeners are based, obviously, repatriation does have more of a legal connotation because of repatriation of Native American material, including human remains. You have an important law, NAGPRA, the Native American Graves Protection Repatriation Act from 1990, which probably the vast majority of your listeners are familiar with. And so there you have repatriation as actually a legal obligation placed on certain museums that receive federal funding in the United States. So repatriation tends to have more of a legal connotation in the U.S., but outside of the U.S., repatriation is often used as a term. I like to think of it as meaning the return to a homeland. If you break down the word repatria, patria is Latin for fatherland or homeland, so the return to a place. So it's slightly different. I think conceptually it's slightly different from restitution. As I said earlier, restitution is more about a past or continuing wrong that's been committed, whereas repatriation is about the return to a place, like it's being returned to a place, potentially regardless of whether there was some injustice involved in its removal in the first place. So I think people in the sector have to take these terms with a grain of salt, with the exception of repatriation in the Native American context, just because they're often used interchangeably. They don't have strict definitions, certainly legal definitions, and so I think it's just important to be relatively consistent. If you're at a museum and you're developing a policy or you're acting on a policy, it's just to be consistent in terms of the terminology used. You could probably tell just by the title of my book that you plugged for me. Thank you, John.
Of course.
I went with restitution just because I think that's a term today, like in 2021, that fits most with the kinds of activities that are taking place, with those returns that are occurring, almost as we speak. I think they are returns with an intention of doing justice for a past wrong. So I think it fits neatly within that matrix under restitution.
Gotcha. So would it be safe to say that, say, for a case of restitution, for example, that could be the return of objects, say, that were looted by the Nazis, but repatriation would be the return of objects more to a government, right? So maybe something that was looted by the British Army or something like that in a past war. Is it something like that, or is it even that important to define the difference?
Well, sometimes you do see that distinction being made, restitution being a return to, say, an individual or a family, like in the Nazi looted art example you mentioned, and then repatriation to a place. Remember the patria, so that could be the country, the government of the country. I think sometimes that distinction is made, but again, I just stress the point that it's not really a legal distinction or a terminological distinction. It's just the way people use these terms. I think generally what we're speaking about is the return of cultural objects, right, either to a community or a country of origin, or to an individual or a family. Yeah,
and so by definition, does it? In these cases, does a wrongdoing have to actually be acknowledged in order to go through with these things with a restitution case? I mean, almost by implication, right? But and do they typically acknowledge a wrongdoing in the past?
It's a really important aspect of it. I actually think the answer is probably going to be case by case, and it will depend on the relationship that's built up between, let's say, the museum on the one hand and the claimant on the other, and what the claimant's needs and requests are. So sometimes it is about that acknowledgement. In other situations, maybe that acknowledgement is not as important because they just want the thing back for, I don't know, ceremonial purposes or in relation to family history or family tradition. There are reasons why they would want it back. And they're not so concerned about an official apology or an official acknowledgement. So I think it's case by case, but it is important, and it's good that you brought it up early, because sometimes based on the relationship between the parties, you need to work, whichever side you're on, you need to work to show respect for the other side. And I think that's often an important way of doing it. And sometimes it might not even involve a return in the end. It might really just be about acknowledgement. And you see in some museums, in the labeling, it might be a question of just recognizing the history of a particular object. Maybe it was owned by a particular family or by, as part of the practices of a particular community. And maybe it's just about acknowledging that in the labeling or online. That might not be sufficient, but that could potentially, based on the relationship that develops, that could be one of the end results.
Right. I imagine, as you said that, I just had the thought that it's probably part of the negotiation of the return where, some cases they probably want the objects only and they don't care about the apology. In some cases, they demand the apology more or as part of the whole thing. But if anyone out there listening has been involved with a case of restitution, repatriation, or has any questions, please, go ahead and put them in the chat. If you need if you're not already, sign in with your Google or your Gmail account to participate in the chat and let us know what you're thinking about. So let's go a little bit deeper here. I was thinking, so is it just me, or is there a large group of recent repatriation, restitution cases that happened lately, or has it always been the case? They just didn't make the headlines. So what's going on here? Did something change?
I think you'll be happy to hear it's not just you, John.
Okay.
I think it's something broader that's happening in our society, and there are a number of reasons for that. One of them, this is more technological, but I think the internet has had a big impact. I think and people who work in collections know, details, information about collections are being pushed out far more now than they ever were in the past, and that's only going to continue. So people in far corners of the world can learn about, an item that might have come from their community or from their family in a way, almost instantaneously, in a way that they simply could not 10 years ago, let alone 20, 30 years ago. Mm-hmm. In those early days, it would have been very costly and time consuming to try to just inform oneself enough to bring a claim. Now that kind of information is being pushed out directly by museums and collections. So that comes onto people's computer screens and they're able to learn about what is being held by different institutions. So I think that's one aspect of it. And that's certainly, we felt, the effect of that over the last couple of years. The other one is in terms of law enforcement, because sometimes when we talk about restitution, it's not just in the museum context, which is, I know, what our focus is today, but it's also in the trade, in the antiquities trade, and in the art trade. And I think that different law enforcement agencies around the world are collaborating now at a level that they just were not doing even 5-10 years ago. So, whether it's the FBI, CIA, Interpol, Europol, the Carabinieri in Italy, the authorities in Egypt or in India or in Thailand, there's just far more collaboration now. Again, I think that's partially driven by technology and just the ease of communication now. And so that's meant that there are more stops, there are more seizures, there are more restitutions from, let's say, dealers or middlemen or people who are actually looting themselves in countries of origin. So I think that is another, cause of the let's say, the avalanche of restitution stories recently. And then I think the final point about that is just that the landscape has changed, the mentality has changed. I think now it's almost like those people who believe in retaining objects are on the defensive. They have to kind of justify their position. Whereas it used to be, let's say 10 years ago, it used to be the opposite. It was really an uphill battle for anyone who was claiming restitution, even if they were within a museum context, even, someone working in a museum. I think it would institutionally very difficult to bring up this idea of maybe the best place for an item is not in the collection or in the storerooms, but might be back with the community or back with the family.
Yeah.
I think those arguments were much harder to make even internally in a museum back then, whereas now I think the zeitgeist has changed, and so it's almost harder to say no, let's keep this object no matter what the history was, no matter what the claim might be. So I think those all taken together, change in technology, collaboration internationally between law enforcement agencies, and then lastly, this shifting mentality has meant that we've seen more claims as a result.
Yeah, gotcha. I have a follow-up question to this, but before we do that, Amanda, what's going on in the chat? Is there any questions or comments from our listeners?
No explicit questions, just another input on terms of definitions. One of our listeners had stated that restitution is the return to the rightful owner, whereas repatriation is the return of someone or something to a country of origin. So maybe just another way of looking at those terms,
right,
and how they're defined.
Gotcha. And also to Alex's point, I imagine that it's maybe it even just depends on what country, right? Each country possibly defines it differently. You sort of implied that the United States has a more strict policy, right, for restitution, repatriation, a strict definition.
Yeah, on repatriation specifically in the NAGPRA Native American context, just because it's actually provided in legislation. Right.
Gotcha. All right. So continuing the previous train of thought, you mentioned greater collaboration and maybe even the zeitgeist. Were there a few, or maybe even just one landmark case of restitution that would have provoked this new awareness and this desire to collaborate more and create a new zeitgeist? Are there some landmark cases?
Yeah, I think, well, what's interesting here is that, in a sense, the landmark cases, and they tended to be judicial cases, the cases that went to court, were about 15 to 20 years ago. There was an important case in the United States, in New York, involving Frederick Schultz, who was an antiquities dealer and quite well regarded up till that point. He was the head of the Antiquities Association in the US at the time, and he was prosecuted and found guilty for dealing in looted Egyptian antiquities. That was 2003, the Schultz prosecution. So that started to signify a sea change. And then in the UK, there was a slightly different case involving Iran claiming back antiquities that had been looted. It was a civil case, not a criminal prosecution. But some of the principles were the same. And I think from about that time, like 2003, 2005, 2006, you started to see a shift taking place, I would say a legal shift, where the onus again started to move from the claimant more to the possessor, where the possessor had more of an uphill battle to try to prove that they are the rightful owner of property. And so that happened, 15, 20 years ago, so not yesterday. But I think it took a while for those effects to have a trickle-down impact on, the way people operate in the trade, the way people operate in law enforcement, the way people operate in museums. So it took a while, but I think as you got to sort of 2016, 2017, it was already well established. The landscape had already shifted. And I think one of the triggering, causes of what we're seeing now has to be the speech by the French president, Emmanuel Macron, in 2017. He went to Africa right after he became president of France. And he made this very long speech about, enforcing collaboration between France and African countries. And he mentioned that there should be restitution, and he said permanent or temporary restitution within the next 5 years of African heritage back from France to Africa. And even though that was said in a very specific context about France and about basically Francophone West Africa, the French-speaking countries of Africa, it had a huge impact. I'm sure you and all your listeners, felt that when that happened, 2017. Suddenly, it was just part of the discourse, and people were talking about that. In the European context, that meant more open discussions about decolonization and the former colonies that European countries held. I think in the U.S. it might have had a slightly different coloring to it, but it was basically a similar sort of approach, that now we need to be very honest about where things came from, how they were removed from their countries of origin, potentially by violence or by some kind of subterfuge. And that needs to be engaged with much more directly than it had been in the past. So I think the Macron speech 2017, there was then a report that was issued about a year later by two authors in France, and that again got the conversation moving. So I think those particular examples were instigating factors in terms of what's now taking place. Where, I mean, literally, I would say not 2 or 3 weeks go by without the announcement of a major return or restitution of some sort somewhere in the world. So museums, I think, are taking this much more seriously. Police and law enforcement are as well. And even people in the art and antiquities trade, I think, are much more sensitive to it than they used to be.
Right. I mean, it really makes you think about what percentage of objects we see in museums, or being dealt by dealers are maybe looted or of dubious origin, right? If it's happening as often as you say, right, it's pretty alarming. And like in the case of like the Benin objects, right? Those are thousands of objects. I mean, these are major cases, and so many objects that are being litigated at the moment. It seems like.
Yeah, I mean, I don't know how many are being litigated directly, like in terms of court actions and that sort of thing. But there certainly are a lot of either voluntary returns or simple seizures by police or customs authorities and return. The Benin bronzes are in a somewhat different category because they were taken a long time ago at the end of the 19th century by British forces, and they now, as you mentioned, there are hundreds, thousands of them, depending on how you categorize them, but they're scattered largely around the world. You have a number of them in the UK, a number in Germany, and then you have quite a number in the US as well, at the Met and in Boston. So, I mean, that's been an ongoing campaign, I think, for people in Nigeria and around the world. They're sort of allies in other countries, trying to get those pieces returned in a significant, meaningful way. So that's something that the museums that are in possession of those pieces are having to confront, I think, quite actively, even though the items came into their collections, sometimes 100 years ago, sometimes well over a generation ago.
Yeah. And I mean, look, I imagine most people listening are, overseeing objects that fall into many of these categories. One of special importance we should point out is objects that were looted by the Nazis, and because that is a constant threat for most people. So is there anything that sort of really provoked that, or has that just been an ongoing thing since World War II, an ongoing provenance investigation?
Well, yeah. I mean, that's a whole category unto itself, but a very important one. I think it plays into what that zeitgeist that I talked about. Right. This idea that simply by possessing an object, if you're a museum, that's not enough. You need to show how it came into the collection, how it was taken originally, and you need to be honest about that history. And I think for a long time, many museums were not, or they were ignorant of it, or they just turned a blind eye. And I think now we're in an era where that kind of transparency and honesty is the starting point. Like you need that. You need to be honest about it, and then you see what comes. I mean, that might lead to a claim in the future, or it might not. But at least you're being transparent, which is part of your public duties as a museum. But in terms of Nazi looted art, there's a long history to that. You're right to point out, from the end of the Second World War, you had the famous Monuments, Fine Arts and Archives section of the Allied forces, the Monuments Men of George Clooney fame. Mm-hmm. And they did a lot. I mean, they returned hundreds of thousands of artworks at the end of the war. But the problem was they returned them to countries. They didn't return them to individuals. It was too big a project to start processing them for individuals. So what that meant is that the countries that received some of these works of art, like France or the Netherlands or Italy, they weren't necessarily that forthcoming with the survivors the Holocaust, who were coming back if they were still, if there were survivors or their family members, and trying to claim these things. So things did go back at the end of the Second World War, but in no way was it a complete restitution of art. And it really took until the 1990s for serious restitution to begin. And what was happening in the 1990s, again, you had more publicization of collections. You had the beginnings of the internet, so it was becoming easier to search collection databases. You didn't have to go and visit individual museums. You had a number of important cases that were coming out, and then the very important seminal Washington Conference, which was a conference involving 44 representatives from 44 countries that took place in Washington, D.C., 1998. And that set the tone for the restitution discussion around Holocaust-looted art until the present, really. And what it said there is that when you can find the heirs or the original owners of Nazi-looted art, you need to seek fair and just solutions. Yeah. And fair and just solutions has become the term that's been used in relation to Nazi-looted art since 1998. It's a very elusive term. I mean, what does fair and just mean? Right. It could mean different things to different people. It could mean one thing to a museum, another thing to a claimant or to a family. But that, at least it set the scene, and it provided at least a framework for those discussions and possible collaborations to take place. So from 1998 in the Washington Conference, you had a number of cases where people actually went to court to try to claim back Nazi-looted art with varying degrees of success. And what's most interesting is, as of 2016, so about 5 years ago in the US, you have a law that was passed by Congress called the HERE Act, or the Holocaust Expropriated Art Recovery Act, for the pedantic among us. And what the HERE Act does is it gives a more generous limitation period to potential claimants to bring their claims through the US court system. So I think as a result of that act, once the effects of it are fully felt, we'll see more claims being brought through the US court system, even though these are claims involving artworks that were taken, 2 or 3 generations ago. So yes. I think that's also, changed the thinking and the landscape in relation to that particular type of cultural object.
Got it. We're almost at the halfway mark. Amanda, what's going on in the chat? Any questions for Alex?
Yeah, there are a few, but I do have a quick follow-up, if I may selfishly put my question in front.
Do it.
Alex, are you finding that a lot of, or maybe you can tell us, is the onus or the burden really on, like, let's say, for example, with Nazi-looted art, on the burden's on the families and the individuals to bring their cases forward or to make claims? Whereas it's sounding like with some of the other things we're talking about, countries themselves are coming forward and making offers of giving back. And I'm just curious, in general, when it comes to repatriation or restitution, where does the burden lie? And what maybe is the role of a museum within that?
Yeah, it's a very good question. And I mean, when I talked about the uphill battle and the burden earlier, it was more in an ethical sense that there's an uphill battle in a sense now if you're trying to retain something, because there's all this pressure, there's media, maybe donors are pressuring one way or the other. I think that legally, the burden, just in general in a court case, the burden always is on the claimant, the person, or the plaintiff, the person bringing the claim. So they have to prove their case, right? They have to bring the evidence, and they have to demonstrate to a judge or a court, why they should get an item back and why they deserve that. But I think at the ethical level, which is often where we're dealing with these things, not in the strictly legal, but in the ethical, I think that's where that shifting mentality plays a role, because you have a different view now, I think, from many museum practitioners than you might have had 20 years ago. You have a different view, even amongst trustees and directors at that level, than you might have had 20 years ago. And that's where I see that let's say, the ethical burden being somewhat different. But again, if you go to court, it's about and if it comes to that, it's about bringing enough evidence as the plaintiff or as the claimant. So the legal burden still remains with the person bringing the claim. I think that's starting to shift a little bit in terms of Nazi looted art because of the HERE Act from 2016. There have been some cases which show that the courts are much more favorable to the plaintiffs in those kinds of cases, let's say the heirs of the original victim of Nazi aggression. And the courts are showing themselves more flexible in terms of what they require from a plaintiff, understanding that, sometimes records were destroyed in the war, people were killed by the Nazis, and so it's very difficult for the heirs of an original victim to put forward, fully convincing evidence that this belonged to their ancestor and that it was taken and here's how it was taken, because sometimes those records no longer are with us. So I think the courts are starting to show more sensitivity to that aspect, even in a legal claim. So that's been the impact of the HERE Act. And I think that's, again, affected the ethical plane as well, because now I think the discussion has to be generally within museums and between museums and claimants more open-ended. Not a question of can you prove to us X? It's more a question of let's sit down and talk it over and let's see what we come up with together. That's the ideal, at least.
So yeah, Amanda, what's going on in the chat? Any questions for Alex?
Sure. So Meg posted a really good one. She actually, because we've been talking a bit about art, but obviously there are other objects of cultural heritage that are not specifically art that are involved in this process. And she had asked, is restitution specifically an issue for only art and antiquities? What about natural history specimens or other types of objects? And you talked a little bit about NAGPRA before, and obviously in a lot of cases that has to deal with human beings and their remains, so it's a different thing. I wonder if you could touch a little bit about that.
Yeah. The whole area of human remains repatriation is a very important one. And actually, in many ways, that predated a lot of the restitution discussions because, NAGPRA dates from 1990, so already over 30 years ago. And those internal discussions have been occurring within museums since at least as far back as then, if not further. So I think that's like the human remains area is an important one. And some of the issues are similar, obviously, but many people who claim, the human remains, let's say, of their ancestors would say that this is quite different because these are actual remains, ancestral remains. They're the bones of our grandmothers and our grandfathers. And, they need to, there's no justification. This is the argument from the claimant side. There's no justification for these to be kept in a storeroom in a museum, right? So that's one view. Traditionally museums might have countered and said, well, they're here for scientific purposes, better understanding DNA and all the rest of it. And that was a debate that was already happening in the 1990s. But I think from the perspective of a claimant, the notion that the bones of their ancestors are being kept in a museum is reprehensible, and so they wouldn't even countenance that as a possible justification. It's a little bit different with cultural objects, because as important as cultural objects might be to an individual or a community, they're still objects. They're not necessarily family members. So maybe the discourse can be a little bit different in relation to cultural objects, but if they're sacred or ceremonial, in Australia they talk about secret sacred items that basically Westerners shouldn't even touch or look at, and you have similar things with Native communities in the U.S. and Canada. Those things they're so closely related to the traditions and history of a group, of a people, of a nation, that to treat them as somehow as cultural objects, that itself might be offensive to them. So I think it kind of depends on what the objects, I don't want to even say the word objects, but what the material might be, because as a result of what it is, you might see that it fits somewhat differently in that discussion that has to be had. But ultimately, I think I just go back to the point that it needs to be a dialogue. There needs to be less opposition between parties, between, say, museum and claimant, and less seeing them in opposition, and more trying to engage and bringing them together, discussing as much as possible, obviously, to try to seek workable solutions for both sides. And I think once that happens, at least that's what I've seen, when they do sit around the same table, metaphorically or literally, they're more able to be sensitive to the other side, and that might be the museum being more sensitive to the claimant and understanding exactly how emotionally connected they are to the material, whatever it might be. And sometimes for the claimant to be sensitive to the museum, like what is the museum doing with it? How is it looking after it, caring for it, researching it, etc. So sometimes just sharing of information can go a long way. And when it's just a letter written one way and then a letter in response and people aren't actually talking and they're speaking across one another, that's when you tend to have these breakdowns of negotiations or relationships. And that's what tends to lead to what I would call the bad cases where there's no resolution or there's just a bad resolution in the end. So it's all about process and trying to engage both sides as much as possible, openly, transparently, and then allowing them to work out a workable solution that works for them.
Any other questions in the chat for us?
No questions, but a clarifying point that one of our listeners made, which I think is important, and you might have touched a little bit on it, Alex, was that with regards to the rulings that we've seen predominantly in the United States, and they clarified only in the New York court system regarding the HERES Act, that there's not really other jurisdictions around the world that are awarding the same or can giving the same consideration to plaintiffs.
Right.
Just
right.
yet. Maybe.
Yeah, that's true. Yeah, the cases. There was one case that was a New York case where there was showing a greater sensitivity to the evidence brought by the plaintiff in that particular case, the Reif-Frankel decision. And it's certainly not the case in other countries. And the way it works for Nazi looted art in some European countries, there are five European countries, they don't deal with these issues through the court system. They go through a different route, a different forum, and it's through a restitution committee or restitution panel that deals with Nazi looted art claims. So the UK has that. France has something like that. The Netherlands, Germany, and Austria, they have these panels. So if you have, let's say you're representing a family, you're the heir of a victim of the Holocaust, and you want to bring a claim in Austria or Germany, you don't go through the court system, you go to this restitution committee, whether it's the Austrian one or the German one, and you bring a claim to that committee. And those committees, there have been criticisms of the different committees, but the ideal for those committees is that they work less on a legalistic basis, and they're more sensitive to the ethical strength of a claim, the moral strength of a claim. Certainly the UK Spoliation Advisory Panel has approached it that way. They look at the moral strength of the claim, and they I don't want to say they disregard, but they lessen the importance of the legal strength or the legal merits of the claim. So those are other ways of doing it. In the US, it tends to be more through court litigation and potential settlement between the parties. And then in those 5 European countries, it's more about an alternative process of resolving restitution claim, specifically in relation to Nazi looted art.
Got it.
Okay. That made me think sometimes there are cases that begin in other countries, but then a claim seems to get filed in the United States. Am I correct in remembering that? And I wasn't sure, what's the benefit of doing that? Is it because they're looking for a certain type of resolution that they couldn't get there, but our legal system allows for it? I'm not sure.
But it has to be a New York or U.S. jurisdiction, right?
Yeah. So, probably the best known case in that respect is the, colloquially known as the Woman in Gold case, the Maria Altmann claim that she brought for the famous Klimt portrait of her aunt, Adela Bloch-Bauer. That had been looted by the Nazis from Maria Altmann's uncle, Ferdinand Bloch-Bauer, in Vienna in 1938-39. And that claim, Maria Altmann, she survived the war. She was a refugee. She came to the United States. She settled in California. In the 1990s, she tried to bring a claim in the Austrian courts, but was unsuccessful because the painting was still in Austria. So that's usually what you do in the law is you go to where the object is located or where the defendants are located, and you bring your claim there. She tried. but the Austrian system was not set up for her kind of claim, and it was putting too much of an onus on her to bring that claim. So she decided to file suit in California instead. And so as a result, you had a case going through the California courts against the country of Austria, which is usually quite a difficult thing to do, because if you want to sue the government of, or the country of Austria, you usually sue them in Austria, but to sue them in the California courts was quite an unusual thing to do. And so Austria defended itself, and it went all the way up to the Supreme Court in the U.S. And the Supreme Court said, no, she can sue Austria, various legal technicalities in relation to that decision, but she can sue Austria in the U.S. courts. So they were about to start a trial in California for Maria Altmann and the other Bloch-Bauer heirs to get back the portrait of Adela Bloch-Bauer, the Klimt painting. And in the end, Austria agreed to have it arbitrated, so another alternative form of resolving the dispute, in Austria, in front of a panel of 3 Austrian arbitrators. And those arbitrators agreed that this painting should be returned to the heirs of Ferdinand Bloch-Bauer, including Maria Altmann. So she was quite an elderly woman at that point, but she was able to get the painting back along with the other heirs. So that's an example, and that sort of thing has happened in other circumstances as well, where you have a claim brought in the U.S. courts, in a sense, because I think on the whole it's fair to say U.S. courts have a broader jurisdiction and are generally able to hear these kinds of claims, provided you get through the various legal loopholes. Whereas sometimes if you tried to bring a claim in Austria or France or Germany, you'd just be shut out, like you wouldn't even have your so-called day in court. So there has been a tendency, especially since that Maria Altmann case, which was 2006, 2004, 2006, she got the final decision from the arbitrators in Austria. Since then, there has been a tendency to at least contemplate bringing U.S. proceedings, even if it's against a foreign state, foreign country, because of that precedent. So the U.S. tends to be a more, I suppose, litigious environment, and where things are settled through the courts more than perhaps in Europe and other countries. And so that, I think, has certainly had an impact in how claimants, whether they're families or communities, have weighed out their options.
Yeah, that's how we do it here. So just as a reminder, if you're listening and want to participate, please sign into your Google or Gmail account and write your comment or question in the chat. So I want to, since we're all stewards of various collections, and I assume since you're listening that you probably might even be a stakeholder in this discussion. What as people who actively document collections, like what should we be looking for if we're sort of onboarding objects that could have potential dubious origins or questionable provenance?
Yeah, well, I think the first step is always provenance research, and you can't highlight that enough, the importance of that research, especially when acquiring material or when you're about to be the recipient of a gift or bequest. And maybe even that latter category more, because oftentimes now I think the modern practice with acquisitions is you do your due diligence.
Right.
It's sometimes, I find certain institutions are a bit more lax when it comes to just receiving a gift or donation, right? The whole don't look a gift horse in the mouth thing. You don't want to start doing all this provenance research when someone has, out of their own largesse, given over a great collection to your institution, which your institution probably wants to have.
Right.
But I think that's equally important, because oftentimes material that might have been sitting in a private collection for 40 or 50 years might be more problematic in a sense than something that's legitimately on the art market today. Not always, but I'm just saying that you just need to be sensitive to the gifts and bequests as well as the acquisitions, which hopefully most institutions are already. So provenance research is really important. That obviously involves, resources and money. So it's important to have the necessary funding for that sort of thing. I mean, we've seen in the UK and in the US, like a number of provenance research specialists being hired at institutions. Not enough as there should be, but at least we're seeing that. Victoria and Albert Museum in London, just as an example, they have a provenance and spoliation curator. Jacques Schumacher, and I mean, he does amazing things in researching the collection and bringing issues to the forefront and making curators aware of what's going on, what the provenance and the history of an item might be. I know that you see that at the Museum of Fine Arts in Boston. You see that around the U.S. as well. So I think that's something that's there, but there probably should be a lot more of that.
Mm-hmm. And just real quick, a slight tangent. Expoliation, is that another synonym for restitution, repatriation, or is that a different process as well?
Spoliation is used usually in the context of Nazi looted art, like the Nazis spoliated art from Jewish victims. But what's interesting is, I was looking, revisiting the debate. There was a really interesting debate on a lot of these issues, a lot of the issues we're talking about now. Believe it or not, over 200 years ago in the UK Parliament, when the UK government was debating whether they should acquire what were then known as the Elgin marbles, which had been taken out of Athens by a British aristocrat who was the ambassador to the Ottoman Empire, Lord Elgin. He had taken them out of Athens, and he was basically penniless and trying to sell them to the British state. And so there was a very open public debate in Parliament, in the UK Parliament in 1816. And they were debating a lot of these issues because there was one side that said we should not acquire this material, and then the other side was saying, no, it would be great for the British nation, we should acquire it. And some of the same arguments that you hear today were being aired way back then. But what's interesting is they actually used the word spoliation even then in 1816 when they were talking about the opponents, obviously, of acquiring the marbles from Lord Elgin. They were saying what he did in Athens was spoliation. These were spoliated works. So that term has actually been used quite a lot over the years. But I think now, usually when you hear about spoliated art, it relates to Nazi looting in the 1933 to 45 period in Europe. Gotcha.
All right. So say, let's just do a hypothetical. If we do find something of questionable origins, what's the process look like if we want to draw attention to it and look into it more and possibly even, consider restitution, et cetera?
Yeah. So I think the first step is always transparency. So if that information is known and you're relatively certain about it, is just making that information available through the website and through museum publications. It doesn't have to be like, you don't have to wave flags around it and make a big deal of it, but just let it be known and be transparent about it. I think that's always the first step. Not hide behind the institutional wall, not hide the information, but just be transparent and come what may. As I said before, that might lead to a claim, or it might not, or it might lead to the invitation of people who might have a better understanding of that object into the collection to better understand it and to work with it. Maybe you'll learn more about it through that process. So I think transparency is the first step, have it always. I think it's always important to have a policy in place around restitution, repatriation. Again, that's publicly available, that's on the website, so that the world knows how your institution deals with these issues. And as long as you follow the steps that are laid out in your policy, I think you can ultimately lead to a positive resolution, whatever that might be. And that might be obviously the object going back or the object remaining where it is with maybe better understanding of its history. So whatever the outcome, I think transparency and then the existence and the promotion of a policy on restitution, repatriation for an institution is the best practice.
Yeah. So, who are the parties involved in a case like this? I assume you need some sort of specialized legal representation. Who else is involved with this?
Well, I don't know about the legal representation.
Oh, yeah?
I don't know if maybe in the U.S. context for various reasons, but I tend to think that the more lawyers involved, the worse it tends to be, because again, it looks oppositional.
Yeah.
And I think this idea of like two parties arguing before a court is not the right model. I mean, sometimes it comes to that if there's a real disagreement about a certain fact or an outcome. It might come to that,
it's
but
the
that
American
shouldn't necessarily
way,
be. Nothing wrong with that. I mean, that's why I say in the U.S. context, it might be different. I mean, if I were a claimant and I saw that, a big wealthy museum in the U.S. had material that might have come from, I don't know, my family many years ago, the best thing I might think of doing is hiring a lawyer who knows this material for sure.
Right.
But I'm not sure if, lawyers' letters back and forth between the claimants' representatives and the museum's in-house counsel is necessarily the best way of trying to engage with the issue as equals to a certain extent.
Yeah, it's good to know.
But I think the process, if there is a policy in the institution and it's made clear what that policy is, it's available on the website, I think you can never go wrong with that, because it's made clear to claimants what hoops they have to get through, like before, maybe you'll sit down with them, what they have to show to demonstrate they're not just a guy off the street making a claim. And then it also makes clear internally for the institution, what steps, like who's the contact person, when does the director get informed, when does the board get informed, when does the board make the decision, how does the board make the decision, can the claimant make an appearance before the board at one of their committee meetings, like all that kind of stuff. I think those are the details that a good policy should deal with, whatever it includes or doesn't include. And then because I've talked to claimants and from their side, they tend to say if there's a clear process and a policy in place, that's the best for them. Like they understand that, they can work with that. I think the worst